we were not allowed to cover this Justice Chitembwe's tribunal. How is that?
Well, thank you, Ben. Now, one thing you need to understand about the workings of a tribunal is that a tribunal in itself does what is called quasi-judicial functions. So that it's not purely what you witness in court. It's not purely judicial. So that even the rules of procedure are a little bit relaxed. You will not witness what you hear in courts, that you are making an application to dismiss that one, to dismiss that evidence. No, it's some form of an inquisitorial process, because we are in search for the truth. Now, the process of a removal of a judge is in itself one that is governed by the Constitution. If you have a Constitution or a copy, you can check Article 168. It gives you the procedure through which a complaint can be made, which body is to be to receive this complaint, how the process is going to be done. Now, Justice Chitembwe was under the Mumbi-led tribunal for his removal. Just like any other tribunal, it has the power and the capacity to come up with its regulations. And one of the regulations, or one of the rules of the regulations that are formed by the tribunals, is that the accused person, the accused judge, is given the liberty or the opportunity of deciding whether he wants a public hearing or a camera hearing. So what you've been seeing with the Masit-led tribunal, the one that is recommending or meant to recommend her removal as one of the commissioners of the IEBC, is that she had the right of choosing whether it will be private or public. And she chose for a public hearing for reasons well known to her. But what it appears from the Chitembwe one, the one that was meant to investigate his removal, is that he opted for a secret hearing. And that is one of his rights. But one thing that you need to understand is that even after the secret hearings, the camera hearings, is that ultimately the product becomes a public product. This is why we are discussing. The report
that was handed to President yesterday.
The recommendations now become subject to public discussions. So that once this tribunal has come up with the recommendation to have him removed, is that the accused judge has a window of 10 days through which he can file his direct appeal to the Supreme Court. So that this is so unlike other tribunals, because other tribunals, if you are aggrieved by the decision of a tribunal, you have the normal mechanisms of appeal. Probably you will have to go to the High Court, then after the High Court you will go to the Court of Appeal, and then subsequently to the Supreme Court. But now the law is drafted in a manner that the only opportunities where the Supreme Court has the direct appeal or the original jurisdiction to entertain matters. Number one, we know too well, the viewers know too well, that in cases of presidential elections, any person who is aggrieved with the presidential elections goes straight to the Supreme Court. Now, in this case, if you are an accused judge and the tribunal has recommended your removal, then you have also the opportunity of going straight to the Supreme Court to have the issue determined.